We're going to be talking about some rather serious and interesting information, although hopefully it'll be nothing that'll cause you too much consternation. What sort of sparked this particular line of study is, I don't know how many of you were aware of the gentleman from Indiana who came out and brought codicil and language to our attention, that the word label, as used on the 1040 form, means a testamentary instrument. I was part of the people that brought that lecture forward, and well, I gave Bunny the information, and because we thought it was interesting to look at it in the language at the time the Constitution was written. My personal study was, what is the Constitution in its noun form? Not what does it do, what is the thing? Of course, we've read Lysander Spooner and all the libertarian stuff that's come forward on it being a contract. But after talking to Bunny, I looked up in Amjur and I found, I think it's under Wills, section 12, if memory serves, that the sovereign has no testamentary power at common law. So that means that the Constitution could not be a will, according to the law at the time. And Bunny called me back, about 2 days later, and she said, Stan, guess what? Property can only devolve to a body politic by trust. So what we've pretty much discovered, and I agree with the woman's, with her research, that the Constitution is a trust instrument, and in order for us to understand the peaceful philosophy behind what we're attempting to do in calling government to task, we have to understand that they are trustees. They are very much trustees, and as soon as we understand that, I think that the people in general are going to have a better understanding of where folks like us are coming from. Bunny, if you would, please.
Good morning. My name is Speakman, and I am an heir of liberty. And we're going to find out exactly what that means very shortly. I'm going to prove to you that the Founding Fathers were very lawful men. These gentlemen would not have gone against the law and they would not have created a document that would have gotten them into trouble. Now, if you logically think about it, what if they had lost the Revolutionary War? They would have been hung for treason, conspiracy, whatever. Okay, so they did create a document that would be legal, lawful, and valid under the king's own law. The colonies had laws when they got here. They brought it with them. They were established at the time of the Revolutionary War and prior to it. And they followed those laws. So when they created the Constitution of the United States, they created it under the common laws that they had brought with them. Now, I'm going to also prove to you that this Constitution that we have here is a trust instrument, and it creates an estate because it all is under estate law. Now, I'm also going to prove to you that the trustees, as far as the heirs, are in breach of trust. And I will show you where you are not an heir, but something else. Now, I'm going to create pictures for you. If you ever put a 2,000-piece puzzle together, there's a little piece here and a little piece there. And we're going to take all these pieces and we're going to bring them in, and I'm going to try to make a picture for you in your mind so that you can actually see it not only in front of you, but inside of you and around you, that you can totally comprehend what we are at effect of today. Now, for example, there's a lack of communication we have with the government. And we have it with each other also. I think of one word and you think of totally something else. You're translating my word in your mind, like the word alienate. Now, how many of you perceive the word alienate or alienation to be a rejection of a sort? Okay. This is going to be the first word we look up in the dictionary. And for those of you who have brought your dictionary, please open it up to alienate.
Which one is that, Russ?
Any dictionary you have. I happen to have the dictionary, the American Dictionary of the English Language by Noah Webster, 1828. I think it's the finest dictionary I have come across, including Black's and Bouvier's. And I use it because in order to know what the Founding Fathers had in mind, what their intent was, you have to understand how they used the words at the time they created something. Okay, I will read it. Alienate. To transfer title, property, or right to another, as to alienate lands or sovereignty. Transfer title. Okay. Under alienation, still we have a transfer of title or a legal conveyance of property to another. So there goes your communication. We now have set up a communication between each other. Have we not?
More proper.
Okay. Now alienation does not mean rejection. It means to transfer property, to sell, buy, do whatever you want to with it. Okay. Now, keep these things in mind as we go along, okay? Take whatever I tell you and put it up in a little pigeonhole so we can bring it down later. Now, there is in your pamphlets, in your booklets, a diagram like this. By the time we're finished with this class, lecture, whatever you want to call it, this diagram is going to be a living, breathing entity to you. It's going to be reality, I hope. If it's not, then I wouldn't have done my job. Now you will notice on the left side, this is the system according to me, On the left side, you see up the top Principles of Liberty, and the preamble, the articles, the amendments, down through Amendment 14. And on the right side, you will find up at the top, it says Principles of Mortmain. How many recognize the word Mortmain? You've read the book.
Not the whole book. I've read some definitions, and I'm a little bit puzzled. So we're going to have to go through this.
Okay, well, Mortmain is a very puzzling thing, too, for me because it's been hidden from us. This is the disease that our country is at effect of today. It is the cancer eating our substance. Now, if you can recall back to medieval times, the Roman Catholic Church at one time in England had England in the palm of its hand in a grip that couldn't be let go. This wasn't just a morale or moral issue, okay? It wasn't because all these good people of England were devout Catholics worshiping the church. They had a legal grip on England. They were sucking it dry financially, spiritually, and physically. And it was a legal grip. According to some authorities I have heard or talked with, that the Catholic Church believing that the Corpus Christi of Christ being perpetual, so was the Catholic Church, i.e. we have a corporation. Okay? Mortmain refers to corporate functions, corporate principles, the corporate way of doing things, and now we shall look up that word in the dictionary. Again, Black's Law is good for the definition, but again I shall read from Noah Webster.
What are we looking at?
We are looking at Mortmain, M-O-R-T-M-A-I-N. Mortmain. French, mort meaning dead and main meaning hand. In law, possession of lands or tenements in dead hands, or hands that cannot alienate. Alienation in mortmain is an alienation of lands or tenements to any corporation, sole or aggregate, ecclesiastical or temporal, particularly to houses of religion, or religious houses, by which the estate becomes perpetually inherent in the corporation and unalienable.
Not transferable.
Mortmain, it means dead hands. Something is in dead hands. It is a death grip on this country. Death grip on this country. The same way it was in England in medieval times. It is the principle our government is working under and upon at this very moment.
Henry VIII saw this.
They all saw this. There were Mortmain statutes. And now we're going to commence to go through the literature. Now, all this Mortmain, put it up here with alienation, okay? Because it's going to be coming up. Mortmain and Mortmain and Cyprus have destroyed our country. We'll get into Cyprus. I like to say Cypre because it's a French word and it sounds very elegant. Cypre. So when I say Cypre, it's C-Y-P-R-E-S-S, 2 words. Cyprus is the ability to change a trust. Okay? The authority, the ability, what such are. Now we're going to go to the preamble. I have the preamble sitting here right in front of you. And we'll be looking at that and going to the English laws. Now, the greatest document ever created was the Magna Carta, as far as I'm concerned. our Constitution today is literally our Magna Carta. Okay? Now, in the Magna Carta, I have given to you, I believe, the whole of it. It's very difficult reading because it's in the Old English words. But if you do read it, and you should, okay, you will notice that it is all, or basically up to a certain point, about inheritances, to inherit your liberty, especially number CAP 1, okay, a confirmation of liberties. Right here, it takes the liberties and says, our liberties are inheritable. We have granted also and given to all the freemen of our realm, for us and our heirs forever, these liberties underwritten. Okay, the Magna Carta makes your liberties an inheritable thing. For as much as we have progressed scientifically, we have regressed spiritually and legally. Okay, we are definitely in feudal times. Now back to the Magna Carta. The first one is about the liberties. The second one is the relief on the king's tenant of full age. Third is wardship, and these are all inheritances. Okay. Fourth is about wasting. Now wasting is very important, okay, because this will come up later. I presume I can see that the 14th Amendment is projected toward people who waste, okay? In CAP 35, it discusses liberties purchased. Okay, if you weren't a free man or if you didn't have a free estate, you literally purchased your estate and your liberties were derived from that idea of purchase. Okay, these are things just skimming the top so far. Now, at 36, we come into mortmain. It shall not be lawful from henceforth to give his lands to any religious house. Now, the reason they had religious house, why they specifically were pointed at religious houses, because the Catholic Church was a corporation. Catholic Church, and I don't mean to knock or poo-poo the Catholic Church or any other religion, it just happens to be the way it was at the time. So, the Catholic Church was a corporation, and they were attempting to prevent it from sucking the wealth out of England. A person would die or was about to die, and he would bequeath his estate over to the Catholic Church for the saving of his immortal soul, leaving the heirs destitute or out on the street. So this was an attempt on their part to prevent that to the Catholic Church as a corporation, because it was in dead hands and they couldn't get it back. It kept revolving in dead hands. Okay? Quia emptors, I put this in there. You should probably read it at your leisure. It applies also. The next page is the Statute of Mortmain, 15 Richard II, 1391, Chapter 5. Again, they're trying to stop the eating of the corporate power in the country. Or am I saying that right? Do we get it? Okay. Now we're going to get in. If you have a question, please write it down so that at the end, after the taping, we can get back to the question, because I hopefully will answer anything that comes up and you can just scratch your question off.
Well, this pertains to the legacy line too. So do these references here match what's in legacy line?
Most of them, yes. This is where I got legacy 1 and legacy 2. Okay. The statute of wills. Now, when the question came up, just what is the Constitution, I had an inkling. I mean, someone gave me the input that, it had something to do with a will. There was will structure in it. So I started to, reading about wills. And it led me to the statute of wills. And in the statute of wills, you will notice by the star where it says, hereditaments holding of the king, his heirs or successors, or any other person or persons by knight service shall have full and free liberty, power, and authority to give, dispose, will, or devise to any persons except bodies, politic, and corporate. Okay? So the Constitution as a thing right there told me it could not be a will. Couldn't possibly be a will. It was against the common law. It was against the laws of England, of which the founding fathers were following. Okay? I then came to the statute of uses, and things began to start looking familiar. In the statute of uses, down at the bottom, where it starts to read that where any person or persons stand to be seized, or at any manors, lands, tenements, rents, services, reversions, remainders, or others, or other, or any body politic, by reason of any bargain, sale, fee-offment, fine, recovery, covenant, contract, agreement, will, or otherwise, by any manner means whatsoever, it shall be, in every such case, all and every such person and persons and body politic that have or hereafter shall have any such use, confident, or trust in fee simple, fee tail, or term of life, 4 years, etc., shall from henceforth stand be seized and deemed and judged in lawful season. This is saying that this creates a trust, a use, actually. I put something in trust for your use. I am the trustee. I'm not only the trustee, but I'm the testator or the trustor. I'm a person who creates it. But I put something into trust so that you can use it. It's actually yours and mine, but you can use it. It's a use. They called it the statute of uses. Trusts and uses are basically the same thing. They fall under the same idea, the same conditions. Okay, that started to ring a bell. To use. Yes, I should be able to use it. And then I came across the statute of charitable uses, and things really begin to look familiar. Now, in the statute of charitable uses, you shall find that which looks very familiar, like the Social Security system, the repair of bridges, ports, havens, causeways, and highways. You will find supportation, aid, and help of young tradesmen, handicraftsmen, persons. You will find the word other taxes in it. Okay, this is a very important statute. The statute of uses and the statute of charitable uses are the big ones. Then on the next page I have the statute of fraudulent deeds, alienations, etc., which is a statute 13 Elizabeth 1, 1570, chapter 5. Now, Elizabeth, this was after the overthrow of the Catholic Church. They were now Protestants and had gained control back of England. What happened was, I guess people just got fed up with the whole situation. They got tired of the corporate Mortmain structure keeping them in dead hands with the death grip, got rid of the king, got rid of the church, and now we have Elizabeth, who is Protestant, and she creates the statute of fraudulent deeds. And in here, you will find that if there's any fraudulent situations over conveyances, like trusts, deeds, you are now in jeopardy. By guileful and covetous or fraudulent devices and practices, as aforesaid, we shall or might be in any ways disturbed, hindered, delayed, or defrauded to be clearly and utterly frustrate and of none effect. If you created trust that was fraudulent, it was of none effect. So therefore, if the Founding Fathers were creating a trust in the Constitution, it had to be lawful. It had to be lawful. We go again to the statute against collusive and fraudulent conveyances, which also upholds this thought and line of idea. Number 3 down in the first paragraph says, or else by any secret intent of the parties, the same to be their own proper use, and at their free disposition. Number 4, colored nevertheless by a feigned countenance and show of words and sentences as though the same were made bona fide for good causes. Still upholding the fact that if you are creating something, it has to be lawful. It has to be lawful. This is the common law. This is the law of England. And this is the law that the Founding Fathers went by. They were lawful men. You will find constantly through these statutes repeatedly inheritances, repeatedly body politics, corporate, so that you can literally separate who is who without everything being piled up into a mishmash. We have the statute of frauds. It's a very important thing. We can't get to the statute of frauds when we go into court these days because the laws and the workings of the Mortmain government is not in its reach. It's not in its reach. We're going to show you how and why it's not in its reach. Okay? So when you go into a court saying, you know, this is fraudulent, the judge sitting there going, no, I don't think so. No, because you can't get to the common law. You are barred. The little diagram I showed you, there was a bar going down between the two columns on the right and the left. There is a bar that goes down between the principles of liberties and the principles of Mortmain. We're literally stuck into Mortmain in dead hands. That's why we feel so frustrated when we go into court, knowing that there is justice somewhere, but we're not experiencing it, we're not feeling it, we don't see it, we don't get it, something's wrong. We are barred. We keep coming up against the steel wall. Now, in order for you to understand where the power lies, the power does not lie in the articles, nor does it lie in the amendments. The power lies in the preamble. It is the preamble that creates the estate. It is the preamble that creates the trust. It is the preamble who tells you who it is, or who it isn't, actually. Okay? You must understand what an estate is so that you can see it. So that you can see the estate lying in here, and so that you can see the trust. Okay, we know that the English laws, it had to be a will or a trust. It wasn't a will. We're going to presume it's a trust because they had to make it legal and lawful. They weren't going to get hung. I don't think so. If I were to create a document today, I try to make my documents lawful. I'm trying to follow their laws, doing it right all along. Okay, so they were no different than we are. And I am a lawful person. You're going to have to turn this one sideways. This that we're going to go into is a book written by an Associate Justice of the Supreme Court, Henry Baldwin, in 1837. It was published. And it's a rather large, it's much larger than what I have given you. It's literally a book, and bless my friend who gave it to me, because she said, well, so-and-so says this, that, and the other, and it's found in here. And I said, oh, well, I'd like to read this. And when I read it, I said, well, so-and-so missed something. He missed on page 3 the first parts of these things. Okay, down on the bottom, you see where it starts out, to me, just above the star. I'm going to read down. To me it seems that it can be made intelligible, we're discussing the Constitution, in all its parts by applying to it those established rules and maxims of common law in the construction of statutes, and those accepted definitions of words, terms, and language in which they had been used and had been received as well known and understood in their ordinary or legal sense. That's why I have the Webster's Dictionary of 1828, because that's what the Constitution was written on. According to the subject matter, in appealing to the common law as the standard of exposition in all doubts as to the meaning of written instrument, there is safety, certainty, and authority. The institution of the colonies were based upon it. It was their free system of jurisprudence, with only local exceptions to suit the conditions of the colonists, who claimed it as their birthright and their inheritance. The common law was their birthright and their inheritance. So they were claiming the liberties that were given to them under the great charters and the laws of England. The Magna Carta bequeathed, brought up the inheritance of liberties. And here they are claiming their inheritance, their birthright. We're having a problem getting to our birthright today. The next page. From the beginning, I guess that's the first paragraph down, the little star up at the top. From the beginning till the consummation of the Revolution, the people of the colonies and states in all successive congresses, they had congresses at the time, took their stand upon the common law and Constitution of England as the heirs of freedom. English freemen, whose custom it is derived from their ancestors to make those tremble who dare to think of making them miserable. God bless them. Heirs of freedom. They didn't claim to be sovereign state citizens. Sovereign state citizenship did not exist. It didn't exist until the king said, "Here is the Treaty of Peace. You're a sovereign citizen," or whatever he said. It didn't exist. Who were they? What were they to call themselves? They called themselves heirs of freedom. This preempts state citizenship. This is who they define themselves as. You won't find a state citizen mentioned in the preamble because it did not exist. But an inheritance did. So did estate laws. So did trusts. So now we have heirs of freedom, an heir. Down on the bottom again, it mentions more about the inheritance left us by our forefathers, our inheritance, the great bulwark of our Constitution, the first and best maxims of the Constitution. You think the best maxim is the Articles or the First Amendment? No, it's in the preamble. It's the first maxim. Venerable to Britons and Americans, whose forefathers participated in the rights and liberties they boasted of and conveyed the same fair inheritance to them. We have a conveyance. Convey, inheritance, freedom. It was called the covenant chain on the next page at the star, between the mother country and them. The charters of the king were their written civil constitutions of government, and the colonies would not part with or lose their hold of this covenant chain. There is a covenant of liberty. Covenant, promise, guarantee, secure, insurance. It's a covenant. Now, you should read this. It's very important. It's boring to read all of this. I've gone through book after document, sucking it all in, absorbing it, getting the picture. And I keep coming up with, and you should too, look for your inheritance. In today's laws, you'll find in, say, Amjor 2D, you'll read a sentence and you go, I don't get this, I don't understand it. Well, that's not talking about you. Guaranteed. When you understand the trust and the estate, then you can go and read something in Amjor and you will find yourself segregating everything because it has been commingled. Everything has been commingled, which is a no-no in trusts. Okay? Now, back to this. On the next page, which would be 6, okay? And please don't laugh. There is a circular object. This is the seal of the Magna Carta, okay? I said not laugh. Okay, that was you, wasn't it? I know. Okay, now you will notice in here, let's see, where do I find out? To the journal, okay, to the journal published by their order. Now we're talking about the Founding Fathers and their first journal of Congress, okay? To the journal published by their order and verified by the autograph of their secretary is prefixed in the title page a medallion of which the following is a facsimile. The medallion is the Magna Carta, the seal of Magna Carta on the first journal of Congress. The Magna Carta of England was the pedestal on which the column and cap of liberty was raised, supported by the 12 colonies assembled by their delegates, declaring, on this we rely, on this we shall defend. They are defending their inherent liberties as enumerated in the Magna Carta. They had written this. This was already written, but they were defending the Magna Carta because the Magna Carta is in here. You don't see it, but it's in there. They were defending it. They brought it down forward and they were passing it on in the preamble. They created an estate of liberty, and it's sitting there in the preamble. Your liberty is an estate. There is page 10, second underlined section. I underline everything. It's for my posterity to find. Page 10, it says, now we're still discussing the Constitution by Mr. Baldwin. And he says that the Constitution, the intent by the framer was to endure for ages to come and designed to approach immortality. Now, it truly is. This is the finest document in the world. It is beautiful once you get to see the picture of it all. What the Founding Fathers left us was the finest estate in trust that this world has ever known. And through guile practices, we, the heirs of freedom, have literally had our estate stolen from us. Our inheritance, our liberty. It is an estate. Now, over on the right, you will see that the Constitution is a grant. Trusts, grants and trusts go in the same hand. They're hand in hand. A grant creates trust. It creates a use. Okay? Let's see, if there's, the grant does not convey power which might be beneficial to the grantor if retained by himself, or which can move solely to the benefit of the grantee. Okay? The government says, well, this is a grant, they granted us power. Yes, we did. The people, the founding fathers granted them power. But the power that was granted was for them to work in a corporate structure and applied only to things that they owned or that which was ceded to them or granted to them. So under their corporate structure, they had to own it, have it ceded to them, or have it granted to them. And that's how the corporation worked. It worked on those things. Only those things. Down at the bottom, you'll see I have the words things written on there. This gentleman is beautiful. I mean, he so defines it. Constitution creates things, not names. We're going to be constantly looking for the thing that it creates. Okay? In the preamble, the thing is the estate. There are no names there. It's a thing. Okay, page 24. Now, in this paragraph that I have marked, Mr. Baldwin starts to discuss no, it's the second paragraph down. States, inherent rights, okay? This is the essence of supreme and sovereign power, which testifies that the ultimate absolute sovereignty is in the several states and the people thereof, who can do by inherent right and power anything in relation to the Constitution or change of government, except depriving a smallest state of equal suffrage in the Senate. Not in the United States or the people thereof as one nation or one people, who in their unity of character or power can do nothing either by inherent right or representation as a majority. Inherent rights of the people of the states, not the people of the United States, but the people of the states. Who are the people of the United States? They are 14th Amendment citizens. 14th Amendment citizens have no inherent rights. Only the people of the states. The several states. God bless you, Mr. Baldwin. You're lovely. The features of the British and federal governments compared. Okay, down by the little arrows. The powers not delegated or prohibited being reserved to the states respectively or the people, none can exist by prerogative or inherent power in any branch of the government. Hence, the effect of a specification of the powers granted and prohibited and the express reservation of all others leaves to the states all the prerogative powers of the king over those subjects which are involved in these four cases, the ones that Mr. Baldwin was talking about, or going to be looking at, either directly or collaterally, on none of which any powers granted to the United States by this Constitution. Then he goes into charters of incorporation, franchises over public rivers, etc., etc. Now then he goes into descent, okay, and he says that the king of England we're discussing is a natural person on whom the crown descends by hereditary right as real estate does. This here is to come to us by descent and distribution. Okay, it descends upon the heir. You don't choose it. It just comes to you. It's yours. It descends like I drop it on you. It falls upon you.
Devolves.
Devolves. We got to try to keep this simple. On page 56, Mr. Baldwin says, in other respects, the great features of both governments are the same. Both established by the people of the estates, E-S-T-A-T-E-S, of one, the states of the other. Each state or estate represented by their representatives in distinct bodies. Okay. Estates and state. Could the state of California be the estate of California?
Sure.
Yeah.
Absolutely. Now we are going to stop and we're going to look for a definition of a state. A state, in Noah Webster's Dictionary of 1829, number 1, in a general sense, fixedness, a fixed condition, now generally written and pronounced S-T-A-T-E. And number 6, the general business or interest of government, hence a political body, a commonwealth, a republic. But in this sense, we now use S-T-A-T-E. So here we have 13 colonies who are going to be, who are 13 estates, creating a document of estates for the people of the estates. And when I say the word state from now on, it is going to mean to you estate, even if it's a capital S as compared to a small s, because there are separate estates. In reality, I perceive the capital S state to be a corporate function in Mortmain. Perceived. Oh, now we can go back. Okay. Okay, page 58, we go into the estates again. And Mr. Baldwin he goes into the estates of England, who they were, what their function was. And down at the marked section, the lords represented the two estates of the nobility and clergy. Okay, page 58. They sat in their own right, representing themselves and property as two estates or states of the nation or realm, wholly distinct from the third estate or state. That estate was the whole body of the people, represented in the convention of the commons. As there was no king, there could be no parliament or house of commons in any other capacity than in convention. Pardon me. This was at the time when the throne was abdicated. Life went on as normal. In England, the representatives still met. They still passed laws. They did everything they were supposed to do until the crown was placed upon another body, human entity, So at this point in our time, you can guarantee that our crown has been abdicated, or they are trying to abdicate the throne by getting rid of the sovereign state citizens as we know them and making everybody into a United States citizen who has no inherent power. The state citizen has it, not the United States citizen. So how do you gain the power? You get rid of the state citizen. This is genocide. This is absolute genocide. Now you can all say they're genociding me, and you know that they are. They have. Whoever they are. We're going to come to find out that you yourself is genociding yourself, or have genocided yourself. But you were forced to. To have this estate has either become illegal or it is null and void, according to law. Not moral law, but according to written law. Now, okay, do we all get what an estate is, as far as, I mean, superficially that we're discussing estates? Okay, and we all agree that we have an estate. Now we're going to find out what an estate is and what it looks like.
What page are you on, Don?
We're going to go to an introduction to the law of real property. This is an excellent little book. This is the little book. It's a little book. It's lovely. It's beautiful. Cornelius J. Moynihan. Now, what does an estate look like? What is an estate? Page 28, Chapter 2, Freehold Estates. Sounds good to me. Freehold, holding it freely. It's free. And you will go to the underline and mark spots. Okay, and we're okay. The word estate is a feudal origin and is derived from the Latin word status. Please send us your Social Security number so we may know your status. What your estate is. It speaks to us of time when land holding was inseparably connected with a man's political and personal status in the community. I say that it is still connected.
Very much so.
The next paragraph. The estate in fee simple is of potentially infinite duration. A life estate, or estate for years, is a finite duration. Life estate, freehold, fee simple. Okay? These are two different types of estates. We have the fee simple absolute is one type, life estate is another. On the other page, an estate in fee simple was and still is the largest estate known to law. It donates the maximum of legal ownership, the greatest possible aggregate of rights, powers, privileges, and immunities which a person may have in land. Now, when it comes to your rights, okay, when it says may have in land, all of your rights as a human being attached to the land or the estate you are in possession of. Okay? You might not own any land, but there is an estate and your rights attach to that particular estate. this estate here was a fee simple absolute. Is a fee simple absolute. Okay. Littleton, in his famous treatise of tenures written in the 15th century, began his book by defining the estate thus: tenant in fee simple is he which hath lands or tenements to hold to him and his heirs forever. This definition is still valid. Now, do you notice right there where it says to hold to him and his heirs forever? This is very important. Just those words. Okay? To him and his heirs forever. On the next page, you will see the statute of uses brought into our line of thought and estate. And down at the bottom, you'll see that the law of real property of today is result of the application of both common law and equitable doctrines, and it was by means of this institution of uses that equity came into contact with the land law. Now we have, it's melding, okay, it's coming together. The statute of uses creating a trust now connects to the land, okay, it comes together. The beneficial enjoyment, like I said, the trust was for your use, a trust is for your use, your beneficial enjoyment, your enjoyment, period. On page 219, let's skip that page. We'll go to the survey of law of property, okay? Because this is where we're going to see the trust or the estate in the preamble. And I wish this was a little clearer copy for you. I must apologize. Down in the paragraph that I start underlining, now in law, when you have an object to convey, they don't use the person's name, okay? It's A, B, C, D, X, Y, Z represent a person, a human being. Black acre or white acre or green acre, some sort of acre, represents the object they are conveying. Okay? So if I say A conveys black acre to B, I'm A, you're B. This is black acre. Okay, now we know that we're talking about people, who I am, who you are, and what I convey. A conveys. So in the paragraph below, okay, we're conveying a fee simple absolute in this paragraph. It was an estate in fee simple, which is the largest estate known to law. It donates the maximum of legal ownership, the greatest possible aggregate of rights, privileges, and powers and immunities. Again, we have said we go to rights. Okay, we're conveying rights. Everything is in the estate. Privileges, powers, and immunities which a person may have in land. Again, it attaches to the land. It is not separate from. It is of potentially infinite duration. By the year 1250, the words "and his heirs" had become the only ones by which a fee simple could be conveyed. The word "be" and his heirs meant be in fee simple without any qualification whatsoever. But the words "be" in fee simple used in a deed would give "be" only a life estate. Okay? The words in the deed had to be and his heirs. The words and his heirs used in a deed were construed as words of limitation. Limitation? Say what? Wrong. That is, they describe the quantum or size of the estate transferred to be. The size. It wasn't a restriction, a limitation was not the restriction, it was the size of the estate. Strange as it may seem, the word limitation is contrary to what you think it should be. It's the size. The words of limitation indicate what is taken. Words of purchase indicate the grantees or persons who take it. We must be very clear. Okay, when you name somebody, now we are saying something about words of purchase. Okay, if I were to say A conveys Blackacre to B and his heirs and his son John, we just limited the size of the estate. We made it smaller. When you name the heir, it lessens it. That is why the heir is not mentioned in the preamble. We the people, A, convey Blackacre, form a more perfect union, establish justice to ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. This is Blackacre. This is the estate. It is the estate. A conveys Blackacre to B and his heirs. Right there is the estate. Do you see it? Do you get it? Mm-hmm. A conveys Blackacre to B and his heirs. It's sitting right there. Have you ever seen it? Did you ever see it before? No, you've never seen it before. It's beautiful, isn't it? It's an estate.
That's right.
It's an estate being conveyed. It is a fee simple absolute, a freehold. Who are the heirs? You can't name them. That's why they didn't put, we the people conveyed to ourselves and state citizens. You say, if they said that, it would have diminished not only our estate, but their estate. They were getting a life estate if they did that. They protected themselves, their estate. They protected our estate. It's of indefinite duration. It can last forever. Infinitely, and infinitively? Infinitely, right. It's a fee simple absolute. I saw this and I thought, my God, that's beautiful. It's absolutely beautiful. It's right there in front of all of us. And we've never seen it. Never saw it. But why haven't we seen it? Could it be being kept from us?